Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson, and let me introduce you to our roundtable of regularly scheduled panelists. First, we have Mr. Todd McFarland, who's the Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We have Ms. Bettina Krause, who's the editor of Liberty Magazine. We have Ms. Jennifer Woods, who's the Director of Government Affairs for the Seventh-day Adventist Church. And we have Dr. Timothy Golden, who's an attorney and professor of philosophy at Walla Walla University. Ladies and gentlemen, thank you for being with us here today. Why don't we go ahead and jump right into our first segment. Our first segment is talking about the religious liberty guidance from the Justice Department that's regarding grant programs. One of the issues that we seem to be bumping into on a regular basis is things regarding guidance, regarding programs, regarding funding, from things that we've been seeing as it related to COVID-19 fundings to other things that have been going on. The court in Espinoza gives you a little bit of guideline regarding the free exercise clause, but the Justice Department felt that this was so confusing that they needed to create a complete task force and also provide specific guidance on how to deal with this. Dr. Gold, I'm going to ask you to just tell us a little bit about this concept, this task force, and the reason for why it was necessary, and really kind of help us to begin to start interpreting whether or not these programs are getting to be more complicated than most people ever thought they would have been.
Thanks, Olin. Well, I think the Supreme Court jurisprudence in recent years surrounding First Amendment religious freedom has taken us into areas in our legal culture, for sure, where we've never been before. For the first time in American history, I think the Supreme Court has given religious institutions and organizations lots of options when it comes to access to public funding. And since the precedent has sort of taken us to these places, I think it's incumbent upon government to help provide some guidance. And I think that's what the Department of Justice is trying to do. So whether it's going all the way back to Zellman versus Simmons-Harris, which upholds tuition assistance programs or school voucher programs, sometimes called educational choice, or whether it's the cases like Espinoza versus Montana Department of Revenue that say you can't discriminate against religious organizations when it comes to public funding. We're in a new space now, and government is trying to articulate policies to help us navigate that space. For me, as I've said before on this show, and I'll continue to say it, I'm puzzled as to why institutions that claim to be faith-based would be so enamored with the idea that they could get money from the government when their faith is something that's supposed to sustain them. And so I'm troubled by the moral implications of this, but legally, this seems like a reasonable move by the Justice Department, considering the legal world that the Supreme Court has ushered us into right now.
But you know, Todd, one of the things that they said in the Justice Department is we want to advise religious institutions how to engage in secular activity and not end up violating their role as being a religious institution. It seems to me that one of the best ways you could do that is to keep them out of the game completely. How do we expect organizations that are trained for religion to be really handling things from a secular standpoint without even intertwining their religious beliefs in any way? I mean, is that even possible?
Not only is it possible, it happens every day. Faith-based organizations, especially social service organizations and other entities, for instance, like ADRA, Adventist Development Relief Agency, provide care, compassion, and services to people in the U.S. and around the world daily without making their faith or adherence to any particular faith a condition. So we have faith-based organizations doing this on a regular basis, doing it well. In fact, some of the oldest agencies and some of the largest agencies providing services and getting grants to do the work the federal government wants done are faith-based. So I think this kind of program and funding stream just simply in clarification is what makes sense. And I don't think, unlike Dr. Golden, I don't think it interferes at all with the faith-based organization's goals, right? So when Adventist Church or World Vision or Catholic Charities or Samaritan's Purse when they go into a community or go into another country to provide support, they're not doing it with the goal of converting them to their religion. They're there to relieve human suffering. And so taking federal money is not incompatible at all with their religious goals and mission.
But Bettina, don't we see a lot of organizations that start off from a religious perspective, engaging in a secular activity, and they still utilize it to proselytize in some form or fashion? If we see that happening in any way, haven't we crossed the line?
Well, of course. I mean, if that is indeed happening, then we have crossed a line. But I think Todd is right to the extent that the issue here is not that religious organizations cannot engage in social service and the provision of social services without compromising their religious beliefs or without engaging in discrimination against those they serve. The problem primarily, I see it, is as one of optics, because the critics of programs such as this will say that, you know, religion wants to have it both ways. They want to have their cake and eat it too. Religion doesn't want to be discriminated against when the money is being handed out, but it wants to claim the right to discriminate in its hiring practices, for instance. So, you know, if that is the problem, then I think that religious organizations need to do a better job at reassuring those critics that they will not discriminate. They will not do what you said, Orlin, and use their the money to proselytize or to discriminate against any member of the society who may want to use their services.
Well, to piggyback off of what Bettina said, and I think this is another point that we should mention regarding this guidance that was given about the grant programs, they made a distinction in the guidance between direct funding and indirect funding. So, you know, if we're talking about indirect funding, which I know previously we weren't talking about, but some of those prohibitions and some of those restrictions don't apply in that instance. As long as the choice of provider is given to the beneficiary, then programs such as certain voucher programs or funding that doesn't go directly to the institution, we don't run into some of those issues that we've just previously discussed.
But you know, one thing that's interesting, I've been reading in particular about a lot of institutions that are involved in education, that they like a lot of these programs because they were not in a position to get enough of their own students or their own people to actually be funding these type of programs. So now, because the schools that you may have are not drawing enough people from your religion, whether it's a voucher program or some other program, it's really kind of to sustain your life as opposed to really you're quote unquote committing or engaging in a service of some sort. Doesn't that create a little bit of wanting to have your cake and eat it too?
I think it does. I'm astonished at how political conservatives can be so terribly opposed to government assistance to people of any kind, except when it comes to using government money to facilitate overtly religious agendas. I think this is a real intellectual dishonesty. And if you're really a faith-based organization, again, I struggle morally speaking with this idea that a church or a religious institution would be willing to get in line to get government money when they're supposed to be a faith-based organization in the first place. And if your own members, if you're not getting enough support from your own membership to sustain your institutions and have to go to the government to get help to do that, to me, that tells me everything I need to know about how serious you take your mission in the first place.
Well, Tim, I'm going to let you be the last word on that, but this is a topic that we're going to see happening for a long time, and I think probably on a case-by-case basis, we're going to find ourselves in court. Let's go to segment 2. Segment 2 is talking about one of these terms of art that we've heard and seen for quite some time, and those in the business, we call it RLUIPA, the Religious Land Use and Institutionalized Persons Act of 2000. Now, this act was put in place to really protect individuals in their house of worship, and they were put in place also to make sure that we can refer to any of the Civil Rights Division, Special Litigation Section as it relates to some of the activity going on. But I know of many jurisdictions that engage in what I would call unofficial activities, in which they're squeezing out activities regarding religious organizations all the time, slowing down permits, putting you in a situation where it takes so long. Is this law really working? And I'm just trying to figure out whether or not we need to do some revisions to it, or do we have anything settled on that to some degree? Jennifer, what's your thoughts on that?
Yeah, well, I think it's important to lay, again, the groundwork of what this law was intended to do. And that is, again, to prohibit some of this illegal discrimination against religious assemblies regarding zoning, and also when they're highly discretionary processes with land use regulation, to make sure that religious organizations aren't being discriminated against. And to address these concerns, RLUIPA prohibits, zoning and landmarking laws that substantially burden religious exercise of churches and other assembly places of religious assembly, absent it being the least restrictive means of furthering a government interest. And they've talked about 5 different provisions that help to protect these rights. So 1, there's a protection against substantial burden on religious exercise. 2nd, there's a protection against unequal treatment for religious assemblies and institutions. 3rd, there's a protection against religious or denominational discrimination. 4th, there's protection against total exclusion of religious assemblies. And 5th, there's protection against unreasonable limitation of religious assemblies. And I do think that RLUIPA has improved the situation. At least now there is an avenue that churches and other religious organizations can turn to when they do feel like they're being discriminated against regarding zoning or other land use regulations.
But let me ask you this question, though, and I'm going to throw this out to Todd. When you have a situation where you have churches that are building what I would call cathedrals on 200 acres of land, taking all of that land out of the tax base for quote unquote religious purposes, don't we think maybe that we've gone a little bit too far? I can't imagine that all 200 acres are being used for what we might call a religious activity. Todd, where am I wrong on this?
Well, so that's a factual issue, right? And I know, I'm not sure of all 50 states, but I know in Maryland, there is a requirement that you must be using the land for your what's usually called an exempt purpose, right? And if you're not, they can tax that. So for instance, we had a situation a couple of years ago where one of our publishing houses had some land that we weren't really using, and the county and state came in and started taxing that, and we turned in some agricultural land, and it worked out fine. So, and to the extent that there can be sort of pushback on that, you don't get to take off the tax rolls unless you're using it for an exempt purpose. But I think a more important question is this law gives an appropriate balancing. It's not just the tax exempt nature of it, but it also a lot of times is animated by just a dislike of the particular religion. I know, talking to a former DOJ attorney who handled these cases nationwide, said, listen, the Christian groups and the mainstream religious groups, those cases always got settled. It was the Islamic, the mosque that need to be built or other the place of faith. We just joined an amicus brief for a mediation center for the Thai Mediation Center. Or meditation, I'm sorry, not mediation, meditation. And, so it is the minority religions that bear the brunt on this.
Well, Bettina, sounds like you're in agreement with him.
Well, I am, because, you need to remember that this piece of legislation has been doing the heavy lifting on many religious freedom issues regarding vulnerable minorities ever since the Supreme Court gutted constitutional jurisprudence on the religion clauses back with the Smith case in the early 1990s. And so this was Congress's response to bring back the strict scrutiny standard that would provide stronger protection for religious minorities. And, is there any more vulnerable situation than an inmate in a federal or state prison? I mean, this is a person whose body is controlled by the government. Look at the case of Ramirez versus Collier, a Supreme Court decision that came down this most recent term. He wanted to have his spiritual advisor lay hands on him and pray audibly while he received the death penalty. Texas said no, and the Supreme Court said, wait a second, Texas, you're not going to be able to meet that strict scrutiny standard under the Religious Land Use and Institutional Persons Act. You have to reconsider that. And so this is an example of where RLUIPA is genuinely providing protection for religious minorities and for those who are the most vulnerable in our society.
Dr. Golden, do we think RLUIPA is still doing the job right now? Or do we think maybe there needs to be even an updated version on it? Because I'm not sure that there's a problem with a jurisdiction that says, you know what, if you want to build a church, I think 100 acres is enough. If you need to be on 200 acres, everything over that probably needs to be taxed. I mean, do we need something a little bit more, or are these organizations and government organizations being unreasonable?
Well, and I think so much of the debates about whether or not these public policy initiatives or acts of Congress are useful take place in hypothetical terms, right? And of course, Article 3 courts under the Constitution are courts of limited jurisdiction that really involve these concrete cases and controversies involving litigants that have actual rather than hypothetical relationships to the outcomes of the litigation. So in short, we have to sort of wait and see what happens as these cases come to the courts. But I want to just go back to something Bettina said, because she made the very important point that along with RFRA, RLUIPA is an amendment to RFRA, and RFRA and RLUIPA are really acts of Congress that came as a response to the Smith decision is RFRA. And then, of course, in 1997, the United States Supreme Court strikes down RFRA as it applies to states in the city of Bernie, Texas versus Flores case. So we need RLUIPA and we need RFRA to help restore what, in some sense, the Supreme Court has taken away. But the Supreme Court has made it clear, certainly in the Bernie case, that Congress cannot usurp the judicial function of saying what the Constitution is or what it means. So we need these statutory supplements as the sort of additional protection that RLUIPA provides.
But Jennifer, it looks like the Supreme Court in many of its decisions is really pushing away from what I used to call the United States of America and pushing into a lot more of confederation of states as it relates to a lot of these different topics. Would it be unacceptable that we would see RLUIPA be put back into the states' hands primarily and let them make the call on what's reasonable? Or is it something else that we should probably hope that the Supreme Court never touches from that perspective?
I mean, I hope that we don't go that route. I hope that we keep RLUIPA at the federal level and apply across the board to all states. The same with RFRA. And it would be nice if, you know, the 1997 decision had not happened and it still applied to the states, because I do think that you having certain rights depending on the state that you're in, that's just it concerns me. I think it's a concerning way to move forward.
Well, Jennifer, I'm going to let you have the last word on that one, but I think we know where we're going with some of these issues, and we're going to find ourselves fighting this out probably in litigation on a regular basis. Let's go to our next segment. This is a segment where I wanted to talk a little bit about a case regarding Kennedy versus Bremerton School District. It wasn't that long ago that we were having conversations saying that the concept of school prayer was pretty much settled. We didn't have to worry about it. We thought that it was laid to bed, and it looks like things may be a little bit different right now. I'm going to ask someone, Bettina, if you could just give us a little bit summarization on the Bremerton case, and then help me to understand why this is going to be okay and doesn't end up creating some issues as it relates to the now a combination of church and state, in particular as it relates to prayer in a public place.
Yeah, you know, Olin, it seems to me that the Bremerton case is, the facts of it are sort of a made-for-TV movie type set of facts, because you have this coach kneeling on the field after a football game, people rushing on, you know, politicians rushing on to kneel with him to show solidarity. It's a dramatic set of facts. But in reality, it's simply the court, as you said, revisiting this old question of how do you calibrate, how do you balance this free exercise rights of an individual against Establishment Clause protections, especially within a public school setting. And, you know, this whole case, you can argue the ins and outs of the facts of this particular case, and they don't worry me so much. What does worry me immensely with this case is the court's abandonment of the so-called lemon test, which is a 50-year-old test which has been used to provide guidance for courts in dealing with this balancing process. But now the majority in Bremerton has said, no, lemon test is no longer applicable. Basically, you've got to just, do this vague looking to historical practice and applying the understanding of the founding fathers, which to me is an incredibly vague, incredibly malleable way of approaching this constitutional question. And it really is an invitation to as many people as possible to start testing just how far the courts are prepared to go in dismantling Establishment Clause protections.
Dr. Golden, looks like we're talking about dismantling of the lemon test. Do you agree with that?
No, I don't. I think the lemon test provided a workable standard. Justice Scalia's rants about it notwithstanding, the purpose, effect, entanglement test, I thought was quite workable. But now, listen, I'm back to my moral objection here. You've got religious institutions getting government money. You've got religious exemptions being made for people to pray in public places on public school grounds, as they wish and so forth. And I'm just wondering, from a moral standpoint, what kind of religious practice is that? What kind of religion emerges from that? Is that really, if you're a Christian, is that the religion of Jesus Christ? Is that the kind of religion we want to have? A religion that's culturally and socially popular, but somehow diluted and not as personally potent or as prophetically potent as it could be? So again, legally speaking, people can sort of do what they want, and the Supreme Court can rule as it sees fit. But I just have concerns for the sort of Christianity or any religion that comes out on the other end. It seems to me to be a diluted ersatz version of the religion, whether it's Christianity or whatever the religion may be. And I'm not so sure it does religion much good at all.
Todd, what's your thought on it?
Well, I think, that first of all, Joseph Kennedy was not volunteer, he was paid, but he was a part-time coach at the Bremerton School District. This isn't your traditional prayer in school case. In fact, I think calling that's a little misleading, because he was not seeking to lead the students in prayer or have prayer before games. He wanted to have a personal prayer out after a game on the 50-yard line. And in other respects, in other settings, we would never say that a teacher can't have their own personal prayer. A Catholic member of the Catholic Church, having prayer before their meal in the cafeteria and doing the sign of the cross would not be viewed as being prohibitable by the school district. And so, it was interesting for me that the liberals, or the dissenters, I should say, which were three of the liberal justices, really had to take issue with the facts that the district court found and of the case to really come to their conclusion. And that's not normally what the Supreme Court does, right? You're supposed to be sort of beyond the facts and talk about the law, but rather to dissent, they had to argue the facts, which is not really the traditional role of the SCOTUS.
But Todd,
unless Todd, you're arguing that the factual findings are somehow not supported by the record. Appellate courts do undertake factual determinations, if only for that limited reason.
But that's not what Sotomayor was doing, right? And that would be a court of appeals. That would be error correction, and that's not the job of the Supreme Court. The district court found that there was one and only reason why he was terminated. That's what the school district argued all the way up. It wasn't until they got to the Supreme Court they realized how weak their claim was. And so then they had to start bringing other tangential issues like, he contacted the media, despite the fact that's a protected activity. People got upset about this, despite the fact that's not a reason to fire a person.
Todd, I think the Supreme Court is an appellate court like any other appellate court.
And it's absolutely not like any other appellate court.
Well, in a sense, it very much is, because it undertakes, as a court of appellate jurisdiction with courts of inferior jurisdiction beneath it, it can undertake an examination of the factual record to ensure that its findings are supported. It can do that. Appellate courts do that all the time.
I don't think they do that all the time. What the district court found, and the typical response for that, again, the district court had found the issue, had found a particular set of facts, and it really seemed more like squabbling in a district court over the facts, not what the Supreme Court normally does. And that's what I think was telling, was that they had to reach down into the factual record and take issue with it. And like I said, a lot of the things that they were taking issue with in other contexts, Justice Sotomayor would have applauded, right? So one of the things she said was, oh, you know, the head coach was upset and there was a lot of media attention on that. Would she criticize a woman who brought media attention on the Me Too movement issue if they were bringing a sex discrimination? I don't think so. But she was willing to be critical of a plaintiff engaging in a protected activity who brought media attention to what he felt was discrimination. So there was definitely a double standard there from Justice Sotomayor.
Well, Bettina, let me ask you this.
I wish we had more time.
Let me ask you this. The idea and the fact that they had to point out that this was done on the 50-yard line, that specificity in and of itself is making a statement. If you want to engage in this activity, why do you have to go to a center of a field, or does that make any difference at all? Because the prayer concept used to be it didn't matter where you did as long as it was in private, but to go to the middle of a football field doesn't seem to feel very private to me. Am I missing something here?
I don't think you're missing something. I mean, from a personal perspective, I think Coach Kennedy knew very well what he was doing in terms of seeking public publicity and the way he went about what he did. However, you know, Todd is right. The facts that the majority embraced supported the very narrow outcome that they came to. And I'm going to go back to what I said before. I am concerned that this conservative majority has now said that we must go forward and continue to interpret religion clause cases with this vague reference to historical practice and founding fathers' understanding, because this spells trouble for separation of church and state going forward.
Jennifer, I'm going to give you the last word on this.
Yeah, you know, again, depending on the facts, what I find concerning is how this excludes religious minorities. And again, this will all depend on how we view the facts of this case and whose facts we want to listen to. But I find that aspect of this case disturbing.
Well, thank you. We're going to have to leave it at that. But as we see, we're going to keep finding ourselves back in court, case by case basis. But, you know, at some point, hopefully we can get this thing codified so we're not fighting about this on a regular basis. Let's go out to our last segment of what we're going to be dealing with today. So, Bettina, tell me something I don't know.
Okay, so we were talking earlier about how religion contributes to social services in this country. Did you know that religion and all its associated activities in the US contributes $1.2 trillion to the US economy each year, which if you put it in terms of GDP means that US religion is the 15th largest economy, national economy in the world. Religion makes a difference in the US economy.
Wow. Jennifer, tell me something I don't know.
Sure. So looking at, again, the Kennedy case and the split of the court, one thing that came out during the Pew Research Center piece in August is that the Supreme Court and views on the Supreme Court are more partisan than they've been in the last 30 years, especially on whether the justices are being influenced by politics in their decision making.
Wow. Todd, tell me something I don't know.
Soon, the Seventh Circuit Court of Appeals, speaking of prisoners, will be considering whether or not a prisoner who was forced to cut his hair, which he held long for religious purposes, is entitled to seek money damages for that violation.
Wow. Dr. Golden, tell me something I don't know.
President Trump will not be indicted, sending the country into a further and deeper vortex of confusion over the status of the rule of law in the United States.
Wow, that's a big one right there. Sounds like somebody ought to say amen. Thank you on that one. Listen, it was great having you guys and really appreciate our conversation today. And to our audience, thank you also for being here with us. I just want you to know if it's about faith and politics, it's about God and government, and I'll see you next time.